To interpolate the distinguished colleague from our distinguished colleague from Taguig and Pateros, Senator Pia Cayetano is recognized.
Thank you, Mr. President. I'm just checking my notes to see where we left off. Are we done with it? Okay, so I'll just move on to the, okay. Yeah. With the sponsor's permission, may I proceed with
Yes.
my questions and clarification?
Yes, Your Honor.
Yeah. Mr. President, I will skip the other definition of terms. I think we can leave this to the staff if I have questions. It would really be more on ensuring either consistency with other existing laws and clarity in the definition. So we can dispense with this for the period of interpellation, and then we can just submit our amendments, our questions and our amendments to the staff, if that would be okay with the chairman, with the chair, the sponsor.
Yes, that would be okay, Chairman.
So we're now on section 4. And to be clear, this is just to spread it into the records. Section 4 scope and coverage states that the provision of this act shall apply to participants in internet transactions where either the online consumer or the online goods or digital service provider is situated in the Philippines, included but not limited to delivery carriers, digital platforms, e-retailers, online consumers, and online merchants. In other words, Tagalogin ko, kailangan isa dun sa mga parties ay are legally based in the Philippines. So with the example included, when it provides for a it provides for a narration of inclusions not limited to delivery carriers. So in other words, a foreign buyer can the internet transaction that would be the internet transaction that is being referred to here that would be covered is pag kunyari may foreign buyer tas may problema siya sa delivery carrier. Covered yon. So kunyari
Foreign buyer.
Kunyari may foreign buyer
In the
foreign buyer. O ito, kunyari may foreign buyer bumili sa Amazon US, tapos pinadeliver sa kanyang kamag-anak dito, tapos nagka-problema sa delivery. Would that be covered? Hindi, kaya ko
No, it would not be covered. It's since the transaction was by a foreigner and he sent it to his
included.
yeah. So it would fall under US law.
Kasama to eh. So I find that confusing now, Your Honor, because in the definition I just read, it said including but not limited to deliverer carriers. So in the example I gave, kung nagka-problema dun sa delivery carrier, even though the portal is foreign-based and the buyer is foreign-based, the delivery carrier is local.
Because from my understanding, they delivered it here. So parang the transaction was consummated abroad, but
Yes.
it was delivered here.
Correct,
So
Your Honor.
in effect, it's as if you sent a package, I guess, here. So it's
Parang
yeah.
to Your Honor, di ba, it's
So
quite
it would still
common.
fall under US. The transaction would still fall under US law, I believe, because parang nagpadala lang ng package dito.
Correct, something like that.
Yes. So in
But-
effect, that's the
Correct, but in the definition, it would make it appear that it's covered because it says including but not limited to delivery carriers. I'll read it. It says where either the online consumer, in this case hindi kasi nga nasa abroad siya, or the online goods or digital service provider situated in the Philippines. Hindi nga kasi bumili siya abroad. Pero sabi including but not limited to delivery carriers. So
we can We can adjust the language to be more specific in that, we're open to an amendment that would make
Yeah.
it more specific.
So I think, Your Honor, we should ask DTI to run these scenarios similar to the scenario I gave, because this will cause problems. Your Honor and this representation have the same understanding na hindi covered. Pero sinama yung, so ano yung purpose na nasama yun? Is that an error? Or is it covered in some other way?
Yes. Yes, Your Honor, we are open to an amendment that might clarify the language a little better.
Yeah.
I can see where there might be some.
But actually, Your Honor, what the point I'm making is I'm also not capable of finding all these errors.
Yes.
I'm asking DTI to fix it. Kasi inimbento ko lang yung question ko na yun on the spot, because I was like, okay, paano kaya tong delivery carrier? Hindi pa ako nakaimbento ng question ng digital platform.
Yes, Your Honor, I will ask the DTI to
So maybe
run some more scenarios. And
if I want to hear those scenarios, Your Honor, they can submit it to, in the interest of time, submit it to my team so I'll read it. What scenario would exclude an online consumer, an online goods or digital service provider, but include the digital platform, the e-retailer? Well, sinama na ulit si online consumer. Parang sinabi niyo na online consumer kanina. So I think this is a redundant, this is a repetitive line. It shouldn't be here anymore.
Yes, I will instruct the DTI to submit more scenarios that might.
And their last line, the last line is online merchant. Hindi pa ba yun the online goods provider? Hindi pa ba yan si merchant? Ano si who is the merchant if the merchant is not the online goods provider? Is that another being?
Online merchant service provider says inside the online goods service provider.
The online merchant, based on here, it says, basically, it refers to the merchant who sells within the platform. Specifically, the definition here is online merchant refers to an organization or retailer selling non-financial goods or services to online consumers through e-marketplace or other third-party digital platforms. An e-retailer shall also be considered as an online merchant if it advertised, aside from its own website, the same goods/services through a third-party legal platform, and the online consumer purchased, leased, or obtained the service of their e-retailer through the said third-party digital platform. So basically, it would refer to those who are selling within the platform. Like if you're a seller within Lazada or Shopee, that would be what would be considered an online merchant.
And who is the online retailer?
It refers to a natural or juridical person selling goods or service through their own website directly to online consumers.
So an online merchant uses a platform.
Yes.
And an e-retailer have their
Good
own site.
website, yes.
So if you have both, then you're both. If you have
Yes.
then you are both.
Yeah.
You are both an e-retailer and an online merchant.
Yes.
Okay, so I'll move on, Your Honor. Maybe the whole provision can just be cleaned up. Because parang ligaw pa rin si delivery carriers.
Yes, we'll run some more scenarios, Your
Yes,
Honor.
thank you.
To address this.
And then for the record, it's very clear here that this act shall likewise apply to all business to business and business to consumer online transactions where one transacting party is situated in the Philippines. No, that's not the provision I was looking for. Ano nga, what were we saying that's not covered? Consumer to consumer, no? Yung parang carousel, right?
Yes.
So it should be business to business or business to consumer.
Yes.
Okay. So that means at least one of the parties is in the business of selling something, correct?
That is correct.
Yeah.
Yeah.
And if His Honor can refresh my memory, because I know I asked this question, but I can't recall the answer. So what do you consider regularity? Like if somebody is regularly disposing of their clothes, which is consistent with our consistent with my view on sustainability, they dispose their used clothes on carousel, no? So they're selling it secondhand. Do they at some point become a regular merchant?
I think in that case, that the purpose that would be just to a personal unloading of personal effects. When we talk about, I think something of repetitive transactions of more regular that have more regularity, and that that would be defined as more of the way I think the example you showed earlier is more of an isolated this, whereas a transaction with regularity would indicate a more business orientation to the seller.
Okay, I think, Your Honor, that requires more deliberative examination, because in the sustainable movement, it is encouraged that you don't throw away old things. You resell it, you give it away, you resell it, you repurpose it. So they might be doing it with regularity. So that's why I said you have to define what that is. Is it by an amount, by the number of times? At the rate people shop nowadays, which is really a sustainability issue, I'm happy that they will have it repurposed and reused. But if it does become a regular thing, then do they fall? I just want these things clarified.
Yeah,
I don't have any strong opinions,
Yes.
but I just want them clarified so that people know where to go. And of course, alam nyo na yung magiging question pang dyan, mga, in good condition daw. Tapos nung nakita ko, sira-sira. Kaya sa magko-complain, tapos sasabihin, hindi ka covered dyan.
Yeah.
Dahil hindi naman regular ang pagbenta niya sa carousel. Hindi, regular na yan. Buwan-buwan may binibenta siya. So, it should be decided now.
Yes, I think I think quantitatively we were planning to leave that to the implementing rules and regulations to give a more specific assessment of what exactly would constitute recurring transactions, the kind of recurring transactions, what would define a C2C. But there is a specific this definition of C2C transactions, which is isolated transactions of an individual or group of individuals with another individual or group of individuals done for personal, family, or household purposes, and not done in the ordinary course of business of any of the parties to the transactions. I guess, like you said, that's a broad. It's a little broader, but if we want to get into the intention was to allow the IRR to get into the specific details of perhaps number of transactions or what exactly would constitute a C2C transaction. And I think we have to be also, sorry, Your Honor, but I think we also have to be fluid about some of these definitions, because if we put in the law, it might limit the ability of the DTI later on to adjust as the marketplace changes. As we know, this is a very fluid.
Understand. Yeah, that is a good point, Your Honor. But okay, so let me pose a question along that line. That person who's disposing of her family's, let's just say not her own, even her family. So, minsan dress niya, then another time jacket ng tatay niya, another time bag ng nanay niya, and then after a while, sasabihin nila na magreklamo, puro low quality yan. Hindi totoo yung quality na sinasabi niya dun sa ano niya. So kung hindi yan, if you consider that kasi personal, you don't consider it that regular, saan sila magrereklamo?
Yes.
Parang
I think if in the event that it's in the event that it's clothes from your family or something, that I think that would fall under more consumer to consumer transaction. But when we talk about regularity, perhaps if it's something you purchase from someone else for the purpose of reselling it, that would be something that would fall under the Consumer Act. Right? If it was purchased. If you purchase it from someone else, we get that. That's what
I-
So yes.
yeah.
Yeah.
Anyway, I think, I hope his honor understands. I'm just asking these questions for clarity when the law is passed, and these questions will come by the.
Yes, like I mentioned, I think when it comes to a consumer to consumer transaction, it's really, when if you look at the intent of the person, it was more as you're selling. In this case, it's the selling of your family's clothes. I
Yeah.
think your intent is not really. There's no regularity in that. But whereas perhaps if it's something that you bought from someone else, perhaps, and you wanted to resell it to somewhere else, then it becomes something that it would fall under the Consumer Act.
Okay. And then, do I understand correctly? I'm going to skip now to chapter 2, section 8. The creation of the e-commerce bureau. The e-commerce bureau, section 8, letter E, will receive business and consumer complaints, no? So the complaints that we're discussing would go to this bureau, correct?
Yes, that is correct, Your Honor.
Okay, so for example, can His Honor help me out here? If somebody bought an airline ticket online and then somebody else bought it through a travel agent and they encountered exactly the same problem, one complaint would go to the e-commerce bureau and another complaint would go to another bureau in DTI. Would that be correct?
Well, the e-commerce bureau would be the one to refer to the proper. I mean, it would probably end up in the same. Of course, it would end up with the company that where it originated from. In the case of a plane ticket, it would end up with the airline company. So even the e-commerce bureau would have to coordinate, and whichever bureau, even if of course the DTI would still assist them and would refer them to the entity, the original entity that sold the ticket, which is the airline.
Actually, His Honor's reply leads me to what was my other question. Letter E, the one I cited, receive business and consumer complaints on internet transactions. Okay, so i-receive niya yon, and facilitate the speedy resolution thereof by the appropriate government agency which has jurisdiction. So in other words, babato niya din dun sa agency. They're not going to process this. They're just a coordinator. Is that the role of, do I understand the role of the e-commerce bureau correctly? They're just a coordinator?
Yes, they're a coordinator. Yes, and again, I think the DTI has a no wrong door policy. So even if they reported the same transaction to two separate entities, but even if they reported to a different department of the DTI, it would still be they would still service the request and refer it to the proper department or entity or whoever business was the one who sold the product.
So in the example I gave, Your Honor, may I know from DTI who receives complaint? What agency deals with complaints of airlines? Airline tickets.
Right now, it's the Consumer Protection Group.
Okay, so yun nga, so mare-refer doon. So because that, I actually think that's more efficient because both would be referred. It's the same problem most likely. And I'll give an actual case. When I flew the other week, I was seated, well, near me was a foreigner, and he was saying that the PAL business class ticket was a scam. Kasi yung binenta nilang seat, wala man lang entertainment tawag doon, entertainment unit, 'di ba? Normally meron nang nakadikit doon. Walang screen. Tapos hindi rin sinabihan ahead of time. Mag-take off na yung plane, saka lang sinabi na hindi ba kayo sinabihan na wala kayong entertainment? So talagang narinig ko talaga yung katabi ko, sabi niya, this is a scam. Kasi hindi, so pag gano'n, saan yan marireport? Pag binili niyo yung ticket online, idadaan sa e-commerce. But I guess it doesn't matter, right?
Actually, they would really be free to choose. I mean, if they have the number of either one of them, or if they only have the number of one of them, they're both entities, whether there's a customer protection group or the e-commerce bureau, either one of them would service the request of the passenger and refer them to the proper entity.
Yeah, but just to be clear, they're not going to handle it. They're just going to refer it to the proper entity.
Yes, they would, of course, they would address the request and they would refer it to the,
Well, that
But-
might
but-
be
but-
confusing when His Honor says address the request, because the request is to solve the issue, to go
Yes.
after the airing party. So just refer. I think that's
Yeah,
that's a
refer.
more accurate response, just to refer. Para lang walang confusion.
Okay.
That's the job, to refer.
Yes.
Because if that's the case, I may even recommend stronger language here that says that the e-commerce bureau does not handle it. Para clear. Kasi ang tagal ko inisip to, so ano ba, mag-handle ba sila o hindi?
Okay.
Might even be better to be clearer. Okay. Anyway, I'll quickly go back to section 4. There's a reference in letter D to Republic Act 7653, but I checked because I don't know what this is. Republic Act 7653 has been amended by Republic Act 11211. So may I just, I don't need a response, but can I just ask DTI to clarify that, Your Honor?
would you like a report or a more specific?
It's just that, Your Honor, it says here, the following shall be excluded from the coverage, Republic Act number 7653. But it has been further amended by another act. So I'm just saying that it might be a better reference, the latest law.
Okay.
So kindly have DTI take a look at that so that we're making reference to the accurate law.
Yes, yes. Yeah, I think they were referring to the definition of like financial products and services as defined under the Republic Act. So they can give the specific reference in that act so that we can be more guided in terms of the definition and the references.
Okay, but what I'm saying is that law has been amended. So
Yes.
the proper reference would probably be the latest law. I don't need any specific provision.
Okay. Yes, that is noted, Your Honor. Thank you.
You might want to say as amended anyway.
Yes, yes. Duly noted, Your Honor.
Okay, I'll move on to the next item, letter E, section 4E. The regulation of the content of online media without prejudice to appropriate actions authorized under this act for purpose of preventing the infringement of intellectual property rights under the Intellectual Property Code. So, the regulation of content of online media is one of those that are excluded. So my question is, as to the content of this online media, then who is now going to handle claims of claims on what malicious content? If it's malicious content, you go to court, that's libel. Wrongful acknowledgement of the owner of the content, copyright violation, you go to the Intellectual Property Office. Let's be clear so we know where they go.
If it is malicious content, that would already fall under the cybercrime law. But
Cybercrime.
if it's something of the nature of intellectual property, that would be the IPO office.
Okay.
Intellectual property
And-
office.
Yeah, okay. How does His Honor I think I'll take this up later on OBR, Online Business Registry. It comes up again later. Okay, can His Honor just elaborate for everyone's understanding? Section 7, equal treatment of online and offline commercial activities. It basically states that unless otherwise specified, this act shall be construed to ensure that those who engage in e-commerce may not enjoy any benefits that are more favorable nor be placed at a disadvantage in relation to other enterprises that offer goods and services offline. I understand what it means, but maybe His Honor can just for the record, because somehow people feel, I don't know, it's a good statement to be there, Your Honor. I agree with it, no? But, and the reason, let's just spread into the record, what is the reason for that?
It goes to the equality between retailers. I think this is a topic that we've heard from our offline retailers often, that the online have advantages, are given undue advantages. So the purpose, that's why we wanted to specify this in section 7, that the one of
That's
the
not the intention.
the act should be construed to ensure that those who engage may not enjoy any benefit that is more favorable, nor be placed in a disadvantage. So it just goes to, it speaks of the equality between the e-retailers and our efforts to make sure that there's a level playing field between online retailers and offline retailers.
Yes, and that's a good point, Your Honor. I do support that because for a while, a few years back, I was even hearing statements coming from, I suppose, online retailers and their supporters that they really want favorable treatment, like they didn't want to be taxed. Does His Honor recall that? I had a question, Your Honor.
Oh, sorry, I thought you were making a
No,
statement.
I
Sorry.
said, does His Honor recall that there were expressions of sentiments of online retailers and their supporters that they did want favorable treatment, like they didn't want to be taxed. A few
Yes,
years ago, yeah.
yes, I've heard those.
Yes.
I have heard of that. Those concerns being brought up. Yes, I
Yeah.
have.
So now we're making it clear. No, pantay lang naman kayo, 'di ba? Pare-pareho naman nagnenegosyo. Pare-pareho naman may mga kailangan bayaran na bills, but everybody has to pay tax. That's what we're.
Well, I think this bill doesn't have any tax implications on it, but I think in terms of the motivation of the bill, I think is clearly to create a level playing field between offline retailers and online retailers.
So how about
But there's no, I mean, it doesn't refer to any tax components at this time.
but how about the registration? Does this bill refer to registration requirements, like getting the
Yes, there's an online business registration, but it only requires them to divulge their name, basic information, which will be given to the DTI, and of course will be available to their online retailer or platform.
So is this the OBR?
Yes, the online business registration.
But the OBR is totally separate from any requirements with the LGU and with national government. Is that correct?
This is in coordination with this will be managed by the DTI.
Yes, but my question is this totally separate and therefore totally separate from the other requirements to start a business? In other words, if you were a sole proprietor, you go to DTI. If you're a corporation, you go to SEC. Then you need your business permit from the LGU. So
Well,
is this meant to be a one-stop shop na wala na yon?
This is meant to be this is simply a requirement for online. It's not meant to be in lieu of any other requirements that may be required of any other business.
So it's an additional requirement. That's what it is.
Basically, yes.
Okay. So to be clear, because I'm not sure and I would be happy to be educated. Is there a provision here that says that? Because if not, I would recommend that there is. That this is not registration in the OBR is not it's not in lieu of exactly what the sponsor said.
Yeah. Well, it doesn't say specifically in lieu of, but we can add that provision there.
Thank you, Your Honor. I think offhand, I think it may be necessary. I'm happy to hear what DTI has to say, but I think it won't hurt to make that clear because some people you know, if when DTI starts promoting this law and they'll say, don't forget to register, some may be of the view that, dun lang pala ako magre-register. Kasi
Yeah, I think you can make that clear. Of course, this is in addition to, I mean, this is a requirement that currently is not required of all online sellers. They're not required to divulge. There's no online business registry, so it would be a useful tool for the DTI as an additional requirement, and also for the sake of enforcing the responsibilities of the seller. So, but we can also include some provision that would promote this idea to make sure that the people will not think that this is the only requirement, and this is something that is in addition to the existing requirements of their business.
How about, Your Honor, I'm told, I actually don't really engage in TikTok, but I'm told that TikTok now has a batawag doon, has an option where if there's an influencer promoting a certain product, immediately it's clickable, go here and shop here. So in that case, would the influencer now be considered a merchant? Technically, that the merchant is not the seller. I would say they are the endorser.
Well, if there's a click feature, they would be considered an online merchant.
They're not.
If there's a
Sorry,
click-
Your Honor.
Yeah, sorry.
The one I know is it's clickable to the store for influencers. Of course, if the influencer has their own business, then that might be. But in many cases, the influencers are featuring a product, and the clickable is an online merchant or an e-retailer. So my question is related to Section 8B. Would the online merchant need to register? Because it says here, anyone else who engages in internet transactions. Is that person engaged in internet transactions by endorsing, by promoting?
Online, it is covered. If it's done online, it's still covered.
So an endorser has to now register
Yes.
with the Bureau?
Yeah, online.
Are we sure about that?
If the influencer is pushing it to the Philippine market, he would have to register
As what?
in the OBR as a merchant.
Hindi siya merchant, wala siyang sinesell na product.
Are you saying he's just
Endorser.
promoting it but no click? But if it's a click, if there's something there that's a clickable and brings him to the site,
Pero not necessarily may kita siya doon. Sometimes may points, sometimes may fixed fee, sometimes, I don't know. Hindi pa ako nakuwang influencer for that.
Yeah. Well, I mean, we can define it differently, but as of now, the DTI would still define that as he's still selling a product, or he's still promoting a product. And there's some, so he would have to register himself if he's going to be promoting something. I mean, what if it's something that's injurious? He would have to still, it would be beneficial to get his information.
Di ba, pag injuries yung binibenta niya.
The view of this representation, Your Honor, is that you might have to capture the influencer in some way, because there are influencers that are really peddling wrong information, injurious information, which
A product, injurious product. It has to be, I mean,
Well, no.
if you're saying information, yeah.
Information
Yeah.
that is related to a product that if used in the manner the influencer is explaining could cause injuries. For example, I gave the example, Your Honor, in my first interpellation. There's now vape products that have collagen. So if there was an influencer, which
Yes.
is actually not allowed by law already, if there was an influencer pushing that, then that influencer should be held accountable. Is that the purpose of this law? Is it covered here? Because under the definition of online merchant, I don't think that influencer is covered, because the definition of online merchant in this bill is selling a product.
Yes.
And selling the product might be different from just promoting. a product. So it's something I am bringing to His Honor's attention so that the proper language can be provided if in fact there is that desire to capture influencers. And if so, is it all kinds of influencers or only if it's applicable? I don't know, Your Honor. I don't know the answers. I am just posing these questions because they are real situations.
Yes. What they call that an advertisement model, which is end users access the service for free since the platform is sustained by advertising revenues. So that's a advertising model for revenue, and it's a business model, and that's why the inclusion of advertising as distinguished from advertisements is included, since its nature its nature is business on a digital platform. So, and if you look at digital platforms, they refer to information and communication technology-enabled mechanisms that connect and integrate producers and users in online environments where goods and services are requested, developed, and sold, and data generated and exchanged, such as but not limited to e-marketplace, delivery service platforms, educational platforms, food delivery platforms, and healthcare platforms. So I guess it's a model of revenue. It's a model of conducting business on the internet, and therefore it is
So,
there
Your
are
Honor,
some requirements, and it falls under the law.
So Your Honor is saying that, His Honor is saying that by promoting a product, that is a form of advertisement, and as such, that is as such, he is an online merchant. I follow so far, but in what way was it captured in definition? I'm just trying to make it be sure that.
Yeah, I guess when you promote us, it's a digital service that you're providing. So it's a business model. There's a revenue model for it. So it would fall under the law since it refers to be a business model. There is a end consumer and is a business to consumer model.
Well, maybe the DTI can just tell us. So where did you capture that then? Here, where? I understand what's being said, but I don't know where it's captured.
Here in
Section 497. Section 4.
here in section 4, line 7, the provisions of this act shall apply to participants in internet transactions where either online consumer or the online goods or digital service provider is situated in the Philippines, included but not limited to delivery carriers, digital platforms, e-retailers, online consumers, and online merchants.
So saan nga dyan, Your Honor?
Well, being a digital service, they consider someone who is engaging in online, someone who's promoting someone who's promoting a product is a digital service provider. Since you're advertising a product, you're earning as a digital service provider. So that's what's included in the scope and coverage in section 4.
And then that allows the online player to take strategy. Well, if you take a look at letter K, which is section 3, letter K, which defines digital service, it refers to a non-financial service that allows the online consumer to create, process, store, or access data in electronic form, or allow the sharing of any other interaction with data in electronic form uploaded or created by the online consumer or other users of that service. I don't think that's what that's what an endorser does.
Well, I think it's access to data, since the data is the information on the product, correct? Your Honor?
So access to data.
Yes.
Does DTI stand by that? I'm going to take another look at this and
Yes, if you would, I can.
I just want it to be accurate. I mean, I'm not
Yes.
an expert. I'm just trying to understand it. So
Yes, as far as the Honor, these representations. That's how I interpret it. But certainly we can ask the DTI, and if there are some amendments, we can certainly propose it, and we can ask for the DTI's opinion.
I don't have any amendments. I'm not the expert. I consider that DTI is. I'm
Yes.
just posting
We
questions.
can we can bring up this concern with the DTI, and perhaps they can I can ask them to recommend something to clarify these concerns. But just in general, if there's a link that will redirect someone to a product, just like TikTok, it is covered. The data was given by the advertisers, influencers, so it will be covered as far as this law is concerned.
Okay, thank you. Next item, we're still on section 8. Letter K refers to, I'll read it, no? Collaborate with financial regulators in protecting online consumers, such as but not limited to facilitating the speedy resolution of complaints of online consumers that involve the use of digital financial services. So ang role ba dito ng bureau is itong facilitate the speedy resolution of complaints? May capacity ba sila to do that when they're just endorsing the complaints to other departments? They're just referring.
Yes.
If not, I would recommend that be deleted during the proper time. But I'm just, seeing, let's be sure that we ask them to do what they have the capacity to do within the confines of their mandate.
As well, under the law, the e-commerce bureau is given significantly more resources than they previously had. Currently, I think they only have 11 employees. And, so under this bureau, under this law, it becomes a large bureau, which would allow them to coordinate with other agencies. And they're even allowed to convene public consultations or interagency meetings to ensure that the online consumers are protected.
Okay, if His Honor believes that they have this ability to do so, I leave it to His Honor's better judgment. I was just worried that we might be putting there something that is beyond their capacity because the resolution of the complaint is with another department altogether. If convening them will effectively facilitate the speedy resolution, then I'm fine with it. I'm just trying to be practical about this approach, Your Honor. I can move on.
Yes, thank you, Your Honor.
Section 9, composition of the Bureau. Would His Honor be amenable to changing the procedure for appointment? Because it's not very common for directors and assistant directors to be appointed by the President. That's very low level for it to go up to the level of the President. And what will happen is this will be vacant for a long, long time. Usually secretaries, USECs, and we usually don't go much further than that.
If I'm not mistaken, Your Honor, when I was in the DPWH, the directors were appointed by the President.
In the recent laws that we passed in the Senate, a lot of the amendments that this representation made was to remove that precisely because, and I leave it, you have DTI with you. If they're comfortable with it, I'm just saying 1 year from now, that remains vacant. I'm going to say.
I can see your point. Yes.
So.
Yeah, no, Your Honor. Me personally, of course, it's better to. I believe delegation's a faster way to do these things. I would be open to that, Your Honor.
That's why
I'm just saying that there is a practice. I'm just saying there is a precedent, but I'm not saying that.
Agree.
Yeah.
And I know there is, and that's why in the last few years we tried to change that with the new laws because it's too tedious to have to go to the President at this level. So that's been the trend, and we will be happy to supply the more recent laws that wherein we removed it from the President. Not to deny him of that power, but it just becomes too tedious to have to wait for the President to act on all of these appointees.
Yes, Your Honor. I share your opinion that delegation is a speedier strategy. So I would be open to any amendment if Your Honor is.
The positions here are just 5 years of experience. That's really like a lot of time for the president to have to work through that. I think the secretary can very much handle that, Your Honor. Anyway, I'll move on. Section 10, referral of complaints. Bureau shall refer any complaint received involving violation of other laws committed in the course of e-commerce activities to the appropriate, okay, we've talked about that. The Bureau shall track any such complaint. So, gagawa ng database, ganun ba to? Gagawa ng database.
Yes, that is correct. That is
Talagang gusto ni Bureau gawin yun, ha? Okay.
Yes, that is, yes.
Luck po sa inyo.
I was given the assurance by the DTI that they would make this system efficient. So I have to believe that they will execute this.
Registration. Yung worry nyo lang yung upkeep non up to date and all. I think it's good for people to.
Mr. President, on the OBR in Section 11, Online Business Registry, I remember when I would travel to the US and I was looking up, this is pre-internet time, I was looking up a company. There's a Better Business Bureau that you can refer to in the US. Parang ganito ba to? Like, will it give you like a status of that company? Maybe not even rate it, but at least can you know, would you be able to tell if this company has received so many complaints? I think that's somewhat important to a consumer.
It will be accessible, but they will, with the DTI will place some controls.
Sige, can we get more information na lang on that, Your Honor?
Yes,
I mean,
sir.
I would like to respect data privacy, but at the same time, consumer protection also to
Yes.
be able to access some kind of information.
Yes. But I believe strongly that the existence of such an online business registry would be a big step in protecting a lot of the online consumers, since now they can refer to we could readily refer or track down any entity who conducts business in the country.
Yes. And then itong Trustmark, this is something that is a new creation. This doesn't exist, no? Trustmark. This is something new.
It is something
Something
new,
we want
and
to
maybe it's something new that can give incentive to online sellers, online merchants, so that they can strive to receive this trust mark, which would signal to the consumer that they consistently follow the responsibilities as stated by the law.
So it says here it's an industry-led trust mark. So DTI intends to work with the industry and ask them to come up with their own rating system or something like that, yung mga in good standing, ganon.
Yes, and the DTI shall periodically assess this industry-led
Okay.
trust mark.
Yeah, I'm okay with that, Your Honor. I always ask in the industries that I've had to work with, particularly like the health sector, I always tell them that I believe in it being industry driven, for them to police themselves, for them to come up to the highest standards. So I think that's a good thing, Your Honor. Just it would be good for DTI to periodically assess. I'll move on, Your Honor. Section 13, digital payments. DTI and BSP shall develop frameworks to incentivize the use of digital payments and promote their education adoption among business and consumers. The DTI, in consultation with the BSP and other relevant financial regulators, shall issue rules and regulations to implement Section 17 and 18 of this Act.
Ligaw lang na.
Ligaw yung
Provision na yun.
Mr. President, I just feel that that last sentence looks kind of lost there. Doesn't look like it belongs there.
The DTI in consultation with the
Yeah. Section 17 and 18 is about the cease and desist.
yes, yeah, you know what? Sorry,
I don't know
Your
why
Honor.
it's there.
Yeah, Your Honor. Unfortunately, that was brought to my attention. That was a clerical error. It actually refers to sections
So what
21 and
is it supposed to be?
Which one?
if you this was admittedly this was a no, this was a clerical error. So the DTI is currently working on the
Okay, just show,
amendment to fix this. Yes,
okay, just show us
but you're
the
correct.
proper
Yes.
time.
Yes.
Thank you. Okay, I'll move on to chapter 3, regulatory jurisdiction of VTI. Where's the C-dash-S? Mm, Can His Honor tell us, Section 15 refers to DTI having primary regulatory jurisdiction over e-marketplace, online merchants, e-retailers, and other digital platforms that sell or allow the sale or exchange of goods, services, and digital products. And then it goes on to say that the regulatory rulemaking authority of the DTI shall be ancillary to any duly constituted regulatory jurisdiction granted to an agency, such as but not limited to DICT, Bangko Sentral, National Privacy Commission. So, meron pa ba tayong ibang iniisip?
When it
Kasi
means,
such as lang to eh. So, may iba pa kaya?
well, basically, maybe there are other if I can just cite some possible, maybe other agencies who might have some kind of jurisdiction over it. What is some LTFRB,
I would suggest,
NTC perhaps.
Okay.
Would be.
I think if we know it, we should include that. It's just better to limit confusion.
Yeah, well, yes, but I think Your Honor, the reason for that is just because the agencies that might possibly be included would be so many to mention. That's why they only gave a few examples. But certainly we can give more examples if as a.
Parang mahirap yan. I don't think that follows in lawmaking that you give a few examples when it comes
Well,
to.
if we can, then we can specify each and every one. It's okay. Yes, we can,
If you
Your Honor.
specify,
Yeah.
I would recommend. If you cannot, yeah, it's a bit of a problem because I mean I've gone through this also with other bills, and really the you really just want to be as clear as possible, Your Honor. So I understand the tediousness of the effort, but you'll really want it will prevent more confusion later on.
Yes, Your Honor, that is acceptable to us.
I'll move on. The cease and I'll make this simple, Your Honor. My concerns on section 17 and 18. My understanding of the cease and desist order is it's sort of like a PRO, like a temporary restraining order. But for us to give the power to the secretary to exercise this, we should comply with the delegation of power requirements, and it should be very specific when it will happen, how, under what circumstances this will happen. And usually, like in a TRO, it's very clear that there's imminent danger. That there, for example, the requirement would be, not for example, the requirement based on jurisprudence for the issuance of a TRO is there exists a clear and unmistakable right to be protected. This right is directly threatened by an act, and the invasion of the right is material and substantial, and there's an urgent and paramount necessity for the writ. So all of these things should be clear before clearly written in the bill. Otherwise, this could be questioned as an undue delegation of power.
Yes. I think it's specific here where the authority, the power to issue the takedown comes from, which is it's in violation of the responsibilities specified within this act, the Consumer Act of the Philippines, or any other applicable trade and consumer protection law or regulations. So he has the right to issue a compliance order directing immediate resistance from committing the said violation or otherwise comply with the law or regulations in question. So I think, Your Honor, it specifies what the purpose or what the infraction committed was in order for the in order for the secretary to be able to exercise his power to take down the website or retailer.
It's actually not clear. It says any violation. It could be a minor violation. It could be a major violation. Would you equate a child pornography site or a site that was, selling contrabands to some minor, failure to declare a detail? I don't think we can. And, the Constitution guarantees the right to life, liberty, and property, and the property includes business properties. The secretary cannot just shut down a business on a mere allegation of some kind of a violation. So these things have to be very clear because there are rights also involved. This is also property rights of the business owners. But again, in the interest of protecting the consumer, you also want to give the secretary that power. I do support the secretary exercising that power, but that is why it has to be well defined.
Yes, I think it says here that they would have to, first of all, it would only be limited to 30 days, the takedown order. And he would have to, and they would be given the ability to present their case after 2 days.
I don't think that's correct, Your Honor. The presenting of the case is afterwards. That's for the issue to take down. So the cease and desist appears to me as
It says here, the Secretary of Trade, upon due notice and hearing, shall have the power to issue an order directing a website or other platform in violation of this act to desist from marketing or offering non-financial goods or services that are accessible in the Philippines, provided that the cease and desist order shall not apply to the payment portal connected to the website page or violating entity. The cease and desist order shall remain in effect for a maximum of 30 days unless otherwise extended or made permanent by judicial order or decision. So he cannot make this permanent. To be fair to the platform, he cannot make this permanent. It's only at most maximum of 30 days. And I think that there are some cases that they really have to take it down, even temporarily, just to make sure that the product, should it be dangerous to the public, has, for the safety of the public, if he feels it's necessary, he should have the power to take it down. And anyway, it's not a permanent takedown. It's
30 days lang naman.
Yeah.
I think it's not a permanent mechanism for.
I would request His Honor to have DTI study itong the line 18, which refers on section 17, which refers to violation of this act. Could be any violation, Your Honor, and some of them may require a cease and desist, and some may not. So this would be I stand by my concern that this could be an undue delegation if that is not properly defined. We normally identify what are the which parts of the laws are being violated that would necessitate the use of this power.
okay. Yes, Your Honor. We can make it. I will work with the Department of Trade and Industry to make it more specific. What is needed in order to issue a takedown order. What are the specific infractions that have to be committed in order for the secretary to issue an order of takedown?
There's actually a section, letter B, but may I request proper wording because it's B and then subsection A and B. So baka this subsection A and B should be I or double I because it's very confusing. It's on page 13, starting line 5 to line 13, section B, and then paragraph B, and then under that it's A and B, tama ba? I may be wrong also in my understanding, but it just looks confusing, Your Honor.
Yes, Your Honor, we can correct that.
Anyway, there is a distinction here being made that the secretary may immediately issue a provisional takedown order to prevent grave and irreparable injury to the public when the following conditions are present. So this one, from my understanding, won't even have any notice of hearing. Is that correct?
Or not saying because there's no
Yes, for a provisional takedown, there's no need for a notice of hearing.
Yeah, may I request that His Honor's staff or DTI take a look at the jurisprudence on TROs so that you can maybe mirror it or something similar, because it's already jurisprudence. We don't have to reinvent the wheel. It already identifies, as I have read earlier, when these kind of powers can be exercised, and those are the ones that stand the test in court, Your Honor, because these are cases that could be DTI could be sued, no, if a business would claim that the takedown was done with grave abuse of discretion. So I'm also doing this to protect DTI in the I mean, I'm the first one to like this because with this kind, lahat ng mga vapes na naka-post dyan na bawal, matatanggal na. So I support it. But I don't want DTI to be taken to court for that because our legislation didn't clarify what were the basis for the exercise of that power. So that's the only reason, Your Honor, that I'd really like this to be very tight.
Yes, Your Honor. Yes, that's duly noted, and I'll work with the DTI so we can tighten it up a bit. We can make it more,
Thank you.
make it clear.
Then I think Section 19 is like the counterpart of the Better Business Bureau, not the counterpart, the opposite of the Better Business Bureau that I was referring to. This is the website that would list if a company has been subject of a compliance order, a takedown, and so on and so forth. So again, I support this, but it should just be crafted and then eventually implemented with due care, because again, it would be infringing on the rights of a business owner.
Yes,
So
yes,
we have to be sure that we properly equip DTI with the guidelines on how to exercise this power.
Yes, Your Honor. I think that it is to everyone's benefit that we support these provisions with the necessary jurisprudence to make it even more efficient and effective. So yes, we will work with the DTI in order to give this to tighten up this provision.
Thank you. Your Honor, I go to Section 20. It refers to the development of an online dispute resolution platform, an ODR platform, as an alternative mode of dispute resolution. My question is, Your Honor, is this online dispute resolution immediately available to a consumer before they go to court, or can they go straight? Must they go through the online dispute resolution before they go to court, or can they go to court and not do the online dispute resolution?
Your Honor, this was meant to be an alternative, not a requirement. So it doesn't preclude them from going to court and filing a case.
This is just saying that ito po na sila before sila pumunta sa dispute resolution. Iba pa yun. Iba pa.
So the requirement, Your Honor, to avail of online dispute resolution is that they tried to resolve it themselves. So for example, an online consumer would show proof that they sent an email to the business and complain what's it about, can they return it, can they get a refund. They just have to show proof of that, and if it wasn't resolved, they can avail of the online
Yes, the
dispute
online,
resolution,
yes.
or actually go to court.
Yes, yes,
Okay.
that is true, Your Honor.
Okay. I leave it up to His Honor, but you might even want to make it a requirement to be before going to court, because it is always advantageous it will help decongest the courts. I think the court system would be happy if this can be the end if this mechanism can solve most of the disputes. That would be very good for our court system. perhaps we can take a look at that, Your Honor.
We'll look at
Yung
the,
dumaan man lang dyan.
Yes,
But that would also require that we support it financially kasi you'll need arbiters
yeah, that would be, yes.
and so on and so forth. But I support this, Your Honor.
But I agree with the need to, the need to declog our courts of these kinds of minor, sometimes minor disputes. So yes, I would, I could work with the DTI also to perhaps give the ODR some more resources to
Yes.
handle more of these complaints so that the courts can be decongested.
I mean, I assume it's already very similar to how the Consumer Act is implemented, but it would really, a lot of it is just miscommunication or minsan may matigas ng naulo na seller, and it would be a big help, Your Honor. It would be a big help if we can do that. Thank you. I'll move on. I think I'm almost done. Just to point out that Section 20, letter B refers to a consumer network. And it's not defined, but if this is the only place where it's used, I'm fine with that. Is this supposed to be the definition that follows? A network of national government agencies that have consumer protection mandates and LGUs which shall serve as consumer dispute resolution contact points? If that's it, I'm okay. I'm just concerned that if the use of that term is repeated, then it should be in the definition of terms. If not, this is the only place, and it's okay.
Yes. This is the existing definition of terms that they have now. So that's the basis for this provision. It's existing, and this is this is what it is actually now. So that's the basis for this provision.
Okay.
So the basis for the provision is.
It would be forward network ang sasabi ng disputes. Maghahandle?
Mr. President, may I ask, is the consumer network the one that's going to handle the ODRs, the online dispute resolution? Because letter C, section 20, letter C says each agency shall designate an office bureau that shall serve as its ODR contact point and communicate its name and contact details to the DTI.
The ODR system will be developed by the DTI through the e-commerce bureau. So not the consumer, not the consumer network.
So,
So the consumer, this is it says it will act as a consumer dispute resolution contact point.
I'm confused, to be honest. What's the role of the consumer network now with the ODR?
If Your Honor would be amenable, I can ask the DTI to go over specifics of what they were, the specifics of what the responsibilities of the consumer network will be. They can go through it just to, and then maybe later on we can propose some amendments that would satisfy Your Honor.
I think so, because it's confusing just from my initial perusal.
Yes.
The ODR shall be, so the ODR is an interactive website which may be accessed electronically and will serve as a low-cost method for redress. The DTI through the Bureau shall be responsible for its operation, including its maintenance. The ODR. So I guess you can post your complaints there and somebody will be answering you.
Yes.
Yeah.
Online.
Yeah. Yeah, I think letter B then is lost in this discussion because letter C is each agency, and I'm assuming these are various agencies that are involved in,
As contact points for this, for the consumers, I guess, that they wanted, like the consumer network and, but it doesn't speak to the platform. This is more of, I think these networks are mentioned to act as contact points for the consumers to access also to possibly access the ODR.
sige, Your Honor, maybe we can just ask DTI to explain it further.
Yes, I can, I will ask the DTI to,
Yeah. The
explain
next
this.
provision is on section 21 Code of Conduct, seems to be pretty straightforward. And then rights and obligations, section 22, rights and obligation of online consumer. May I know if these remedies of the consumer are the same in the Consumer Act, yung itong repair or replacement of products within 30 days? Ano nga ba yun?
Remember we just had that question in. But there are certain things that you can.
Are they different? Are the same? Or
Is it consistent?
the same? Sure, yeah. They were based on the consumer.
Okay. Yes, they were based on Your Honor, they were based on the Consumer Act, so they're the same.
Parang I recall, but I may be wrong. Isn't one of the remedies here at the choice of the consumer, whether they'll have it repaired or they'll have it replaced? Anyway, it's in the Consumer Act. I'm going to check this in order to save time. I'll just check it on my own. But if Your Honor tells me it's the same, I hope I don't find anything that's different.
Is there a difference?
According to based on my talks with my information from the DTI, it is
It's the same. Okay.
substantially the same, I suppose.
And then
Marketplaces, yun nga yung platforms. So sila, update sa atin.
may I know where it is stated here in the obligations of the e-market and other digital platforms, wherein they will not allow the sale of products that are regulated by other laws? And again, I'm referring to like the vapes. Bawal, pero nandyan.
By other laws?
Yeah, because di ba, like the vapes are regulated by other laws eh.
You mean from other laws from other countries or other?
No, sorry. We have laws in the country
Okay.
that regulate different products. So if there's a law that regulates a product, where is it that in this law, in this bill that says that the e-marketplace will not allow the sale or will shut down, take down?
I think this may apply on page 20, line 15. E-marketplaces and other digital platforms should not allow the sale of regulated goods such as, but not limited to, chemicals, food, and drugs without requiring them to provide their permits and license information
Okay.
and contractually obligating their compliance with sales procedures and limitations.
Okay. So, but this, and I'm happy with this because this is my main concern, products that are otherwise regulated by the FDA. But I'm sure there are other products regulated by other agencies, which I don't know of. So, saan yun? I don't know I can't think of offhand, but I'm sure there are others. Like, for example, I don't know, online
Yeah.
sale of insurance?
Yeah, I think but it says here in the last sentence, another for the sale as may be imposed by any law or local government regulation. So this, this basically covers almost basically all products, any law or local government regulation.
Maybe what I'll do, Your Honors, I'll ask my staff to submit to your office a list of products that I see advertised or sold online in other countries, maybe not so much here, and I'll ask, if it will be because of this. I mean, I'm all for expanding access, but also to ensure protection.
Yes, Your Honor.
So
That
just
that would be
admit
very
that.
helpful, Your Honor.
Yeah.
That would be very helpful, Your Honor. Thank you.
Mm. I have one more comment. I noticed that there's lengthy discussion on the rights and obligations, and some of them are basic obligation and contracts covered, which are provided in our civil code. I don't know if it's a good idea to be rephrasing or rewording it because we might be creating something new. So I haven't had a chance to go through it in detail. I just know that I see them there and I'm like, oh, oblikon na to eh. May batas na tayo dyan eh. So may I just ask that the legal team of DTI review it with that in mind, that don't try to reword it, don't try to reinvent it. If you're just going to say that, the civil code provision on sales governs, then that's
say
what it
that.
is, We keep it simple
Yes,
because we
Your Honor.
might create something new.
That's true, Your Honor. Yes, Your Honor. I will direct the DTI to do just that, the legal
Yeah.
department, so that we don't, like you said, reinvent the wheel.
Yeah, so my team will just be also reviewing it from that perspective because I just don't want to create confusion. Yeah, I think that's it, Your Honor. I think any other comments I have can either be submitted in writing for clarification or during the period of amendments, no? Just to tighten up wordings and language to make it as clear as possible. That's all, Your Honor.
Thank you very much, Your Honor. Thank you.
Thank you.
Thank you, Senator Pia Cayetano. Just wait for the Majority Leader. Session is suspended.